Steggall.
Thank you, Madam Deputy Speaker. I rise today to speak on the Public Interest Disclosure Bill 2022. And now this is an important piece of reform that strengthens our whistleblower protections. It reforms the current scheme, which in 2019 was labelled technical, obtuse and intractable by a federal court judge. So why this is so important? Obviously to encourage and enable more whistleblowers to call out wrongdoing in services, but also because these are essential to the operation of the National Anti-Corruption Commission, which will soon be underway and for which we passed legislation only a few months ago. Why is this so important? Well, the big difference with the model of the National Anti-Corruption Commission that was passed by this government as opposed to the one proposed by the last government, the Morrison government, was that independent referral pathways for alleged or concerns about wrongdoings. Now, this is where whistleblowers play such a huge role because they have that ability to identify, to be privy to information and raise the alarm and awareness to those wrongdoings. Without protections, though, they then face the retribution of government and face prosecutions. And I should say it was very commendable that one of the earliest actions of the government was in fact to drop the prosecution of Bernard Colliery. But there are, of course, many cases still on foot. The most prominent, of course, Julian Assange, that has been languishing for much too long without any real active engagement in obtaining his release, McBride and a number of others. So it is really important for us as a society to have whistleblower protections because they do play an intrinsic role in anti-corruption and ensuring that public service and decisions are made for better good and that there isn't a corruption of processes. So as many have outlined, this bill does give effect to long-standing recommendations and improvements to the Act. The bill will give greater flexibility in the way agencies handle a public interest disclosure, including information sharing, so that the disclosure can be investigated by the most appropriate agency, increased protection for disclosures, and gives witnesses the same protections as disclosures. Greater oversight of the scheme by the Ombudsman and the Inspector General Intelligence and Security. Disclosures can be investigated under another law or power, including, which is welcome, the National Anti-Corruption Commission, and personal work-related conduct to be removed from the public interest disclosure scheme unless it relates to systemic wrongdoing or is a reprisal action for a disclosure. So these changes are welcome and will deliver immediate improvements to whistleblower protections. They respond to many of the concerns and recommendations made in the 2016 Moss review of the Act. And I do note for members of the now opposition that after so many years that it was in their power to make these amendments much sooner, and I think it would have been to the benefit of Australians had those amendments and recommendations been made. The government, and I welcome, has committed to a comprehensive review and potential redraft of the Public Interest Disclosure Act to address the complexity of the scheme. And I would urge the government in conducting that review that they consider the implementation of a whistleblower protection authority as advocated for strongly by the member for Indi, the member for Clark and Transparency International Australia, among others. The Human Rights Law Centre said that these reforms are an important first step. However, there are large technical changes to make administrative improvements and they don't yet address the fundamental issues with the law. So we do need a comprehensive reform of the legislation to address private sector, public sector and media whistleblower protections. AJ Brown of Griffith University points out that our laws are still very reliant on whistleblowers themselves, having the legal resources and the money to be able to go to court and fight for their own protection, which does put a very onerous responsibility on them when, as a society, we benefit from their courage and bravery in becoming whistleblowers because they do alert us to wrongdoing and corruption. A whistleblower protection authority would aim to address that gap. So, in conclusion, I welcome this reform I commend the Attorney-General for taking on these recommendations and urge the government to expedite its review of the legislation to ensure protection for whistleblowers in the future. And I do take this opportunity again to urge the government to act on the case of Julian Assange. It has been way too long. It is intractable. I appreciate that, but there must be a way to resolve that issue, and in relation to McBride as well. We need to have a situation where it is the alleged wrongdoing that is prosecuted, not the whistleblowers. Thank you.